Okay, well, we'll go ahead and get started today. Welcome, everyone. We're always glad to have you on, and always glad you share some time with us once a month in the afternoon as we all try to make sense of all of the continued craziness in the world, and particularly on the legal and tax front or landscape. Um, if we can go ahead and advance, Greg, to the next few slides, and you can go ahead and go past. There's me, there's Matt, there's Edward, there's Ryan, there's Greg, and there's the beginning of our presentation. So we are going to be focused today on really, for those who have tuned in before, you know, we keep a very, very fast pace. We try to cover as much material as we can, and we're going to do that today. And we're going to focus on IRS enforcement initiatives. What do you need to know right now? Recent tax court developments, property tax issues, the syndicated conservation easement settlement initiative and related issues, and all important bankruptcy developments, which are we are all seeing more and more of, and is something that for those out there advising your clients, you need to have awareness of, and Greg will help walk us through that. On the IRS initiative enforcement front, there haven't been, I would say, major revelations since the last webinar. The IRS continues to be focused on and continues to tout its focus on several particular areas. Probably at the top of that list right now is the conservation easement front, particularly syndicated conservation easements that the IRS believes are or has classified as listed transactions. And Ryan is going to walk us through some recent developments there in terms of the government's, the IRS's new syndicated conservation easement settlement initiative that has been rolled out by IRS Chief Counsel. And we continue to see updates there. One of the other enforcement initiatives that needs to be on everyone's radar right now, and this is something we've all known is coming and have been talking about it now for quite a long time, but I'm starting to see the first big audits and enforcement pushes on this, and that is partnership tax audits. And we'll be coming out before the end of the year with a program really focused around the new tax audit and litigation regime, the Bipartisan Budget Act, for many of you who are familiar with it, which replaced TEFRA from 2018 going forward, and is the biggest thing in tax enforcement that you may not have heard of. And so we want to make sure that information is all available to you. And last time we gave everyone a link on here, kind of to a beta version of a website that we developed, which is called www.partnershiprepresentatives with an S. And that is really an all-inclusive resource for you, because you're going to be, for those who haven't seen them yet, you're going to be coming across that. One other area, and then I'm going to turn the mic over to Ryan, but one other area that we're seeing now in particular is in the international arena. And in particular, we've seen the IRS sending out letters and initiating, some of them soft letters, some of them initiating actual audits related to Section 965 transition tax issues. Again, we've all known this was coming, but I think I know we are going to continue to see an escalation in the IRS's focus on transition tax issues, Section 965. And as many of you will recall, the Tax Cuts and Jobs Act enacted a so-called transition tax for certain offshore entities with U.S. ownership, and also enacted as part of that an greatly extended statute of limitations for auditing and assessing related to Section 965. So have those on your radar. the big domestic issues we see the IRS pushing are micro captive insurance audits and enforcement. And then again, as I mentioned at the beginning, syndicated conservation easements. And with that, I'll turn it over to Ryan to help walk us through and give us some background on that particular area.
Sure. And thanks, Jason. And thank you, everyone, for joining us here today. And I'm going to be talking about this new syndicated conservation easement settlement initiative that was set forth by the IRS Chief Counsel Office. And so the first thing I want to go over, and I don't want to spend too much time on this, so I really want to get to the meat of the actual initiative here. But really, first we have to discuss what is a syndicated conservation easement. Why exactly are these being used? How is this exactly a current target for the IRS? And then what are the guidelines for this new settlement initiative? So with that, we'll move on to the first question, which is, what is a syndicated conservation easement? Well, the Internal Revenue Code generally will permit a deduction for a charitable contribution as that term is defined in Section 170. And so under that Section 170, the charitable contribution is a contribution or gift to or for the use of certain qualifying organizations. And then under Section 170 subpart F or subsection F, a taxpayer generally may not take a deduction for a contribution less than the taxpayer's entire interest in the property. However, Section 170 subsection F, Section 3, Cap B, triple I, which is quite the mouthful, that provides an exception to this general rule when it comes to what's called qualified conservation contribution. So that's really what we're looking at here. And so what is this qualified conservation contribution? Well, under the regulations in Section 170, that's defined as a contribution of a qualified real property interest to a qualified organization exclusively for conservation purposes. And so the thing that I really want to note here is that these definitions, there's a lot of nuance here that I'm not getting into, but just be aware that there are a number of restrictions and definitions out there that can affect the tax treatment in different scenarios. So generally speaking, the scheme here allows investors to claim an outsized tax benefit by investing in some property for a relatively small amount, getting an appraiser to value it at a much higher amount, and then claiming the parcel of land will be set aside for conservation purposes rather than development, and then taking inflated tax deductions under that Section 170. And so typically these are called syndicated conservation easements because these are typically organized by a promoter who puts together a group of investors. You see conservation easements largely as a method to lower tax bills rather than the actual intended purpose, which is to conserve the environment. So that's really where the term comes from. And moving on here, it's the reason why the IRS is recently interested in this is mainly because of the recent Senate Finance Committee report. And so on August 25th of this year, Senate Finance Committee actually released a bipartisan report condemning the use of syndicated conservation easements. In fact, they called them abusive and encouraged the IRS to take further action to really clamp down on these types of arrangements. It's about an 18-month long investigation by the Senate. And I'm actually going to read just a short excerpt here from the report because I think it really puts into perspective how they're really looking at this. And that report said as follows. This report finds syndicated conservation easement transactions to be transactions to provide tax deductions to high income taxpayers by way of inflated appraisals of undeveloped land through partnership entities that appear to serve no non-tax purpose for existing other than the provision of tax deductions. So that goes back to my explanation as to what is a syndicated conservation easement. And so the Senate really said, man, these promoters are just going to extreme lengths to make these transactions appear legitimate. But the Senate, through the use of subpoenas, was actually able to get some emails that showed this is not really a legitimate setup at all. It's really purely to avoid income tax. So really some statistics to note here is that the IRS estimates between 2010 and 2017 that the syndicated conservation easement transactions generated almost $27 billion in deductions. So it's a pretty massive effect here. And so as a result of that Senate Finance report and among other investigations, the IRS has really clamped down on that. And part of that has led to this new settlement initiative. So what exactly is this settlement initiative? Well, these transactions have become so commonplace that the Chief Counsel's office at the IRS has actually issued guidance regarding settlement procedures for SCE cases. That's syndicated conservation easement. Now, generally, this option is being offered to partnerships in order to make litigation more efficient, given the massive number of cases that we just talked about. And so really what it does is it provides a standard settlement offer to specific partnerships and partners with SCE transactions currently pending in tax court. So who really qualifies for this type of program? Well, according to the IRS, it's only partnerships with cases currently pending before the tax court that also receive letters inviting them to elect into the settlement program. So it's really at this time reserved solely for partnerships that are sitting in tax court with these types of transactions. And even then, the Chief Counsel office actually has to invite the taxpayer into the program, at least as it stands right now. And then, so generally speaking as well, all of the partners in the partnership must agree to participate. However, there are some exceptions to that rule. So exactly how does one participate? Well, there's an attachment to notice 2021-001, which is the notice from Chief Counsel office of this initiative. And that attachment just has a form there for the partners to fill out and the partnership to fill out. So once the partnership receives that offer letter, the attachment needs to be returned within 60 days to enter into this program. So what's the benefit of entering into the program? Well, essentially the partnership will have to make a lump sum payment representing the aggregate tax, penalties, and interest due from each partner. So that lump sum amount must be remitted to Chief Counsel when the return or when the partnership signs the closing agreement. So that payment of the settlement amount is actually in lieu of any deficiency in tax or penalties that would have been accessible or collected against the individual partners. So under this new program, the partnership is actually going to be making the tax in lieu of the partners and in lieu of a deficiency assessed against each individual partner. However, all the deductions, losses, and all of the benefits arising from the transaction are disallowed in full to the partnership and its partners for all taxable years. And then certain partners in the partnership can also actually take an ordinary deduction from gross income equal to the net out-of-pocket cost to participate in the SCE transaction. So there is a little bit of benefit provided to the individual partner. And the last thing I want to go over here before I send it over to the next presenter as well is penalties under this new program, which I think is the most interesting thing to note. So typically in these situations, an accuracy related penalty is generally going to be assessed. And so in the guise of an accuracy related penalty in this scenario, the IRS will charge those penalties against the partners. However, they're going to charge them in different percentages based upon the category of the partner. And so I'm not going into how to differentiate between categories of partners just for lack of time. But essentially, the difference between the two is the level of participation in marketing and putting forth the actual conservation easement scheme. Where one category is really going to be directed more at the promoter, whereas the other category is going to be more directed towards the participants in the program. So really, the thing here is the highest penalty rate is going to be assessed against Category 1 partners. And again, those are generally going to be the promoters or those really involved in facilitating the transaction. Whereas Category 2 partners, the penalty rate that they're going to be charged is going to be dependent upon their investment in the actual transaction. and basically the comparison of that, the deductions that were being taken versus the actual investment in the transaction. And then also a 6707 Cap A penalty, those are generally going to be applied as those are listed transaction penalties. And those are included in the settlements. However, if that transaction was not disclosed, that penalty is computed under 6707 Cap A for each non-disclosure. And that the same goes for each partner as well. However, those penalties can be avoided if the partnership and all partners provide evidence through documents or affidavits that the partnership and its partners timely made the disclosures that are required under the regulations. And so I hope that gives you just a really quick overview and understanding of this program. It's incredibly new. In fact, I think there's only been a handful of cases, maybe 1 to 3 cases that have been settled under this new program since August. And this again is not an exhaustive list of all of the requirements and definitions, but I hope that this gives you at least a quick understanding that you're going to be able to look into later. And with that, I will pass it on to the next presenter.
Thank you, Ron. So this is Matt Roberts. I'm going to just go over a couple of tax court cases, recent ones in the last month that have come out. The tax court has been, as usual, fairly busy during October. There have been over a dozen cases. These kind of caught my eye for various reasons, and I just wanted to throw these out to the listeners to kind of keep on their radar if they happen to have some of these issues in the cases that they're dealing with. A common theme in all these continues to be Section 6751B. The tax court continues to wrestle with that procedural requirement in the code and what it means for purposes of various fact circumstances. We also had a case in the last month on gambling losses, and then we had one on also whistleblower claims. So Oropesa v. Commissioner, it's a division opinion that came out a couple weeks ago, again on 6751B. And for those that are not familiar, that provision generally requires the IRS to obtain written managerial approval of certain penalties in the Internal Revenue Code prior to making a formal communication of that penalty to the taxpayer. And the legislative history of this penalty provision that was added in 1998 to the code is generally Congress did not want the IRS to use the potential for penalties as a bargaining chip to get taxpayers to back away from other tax positions that they had taken on their return. So in Oropesa, the IRS had opened an exam of the taxpayer's 2011 tax year. They sent the taxpayer a letter 5153 and a revenue agent report. And in prior decisions, the tax court has generally held that the penalty must be approved before this revenue agent report that generally gives taxpayers appeals rights is sent to the taxpayer. So in the revenue agent report, the IRS asserted a 20% accuracy related penalty under 6662 attributable to one or more of negligence, a substantial understatement of income tax, a substantial valuation misstatement, and a transaction lacking economic substance. So it was based on a variety of different ways that the IRS could assert a penalty under 6662. 14 days later, the IRS agent's immediate supervisor signed the civil penalty approval form authorizing assertion of just the penalty for substantial understatement of income tax. A few months later, the IRS issued a notice of deficiency to the taxpayer, determining the 40% penalty under 6662B6 for non-disclosed, non-economic substance transaction in the alternative of 20% penalty for substantial understatement or negligence. Next slide. So once again, the court is put in the position of determining under this set of facts whether the IRS actually complied with 6751B. The court ends up holding in a line aligned with their prior jurisprudence that the 5153 and revenue agent report was the formal communication to the taxpayer. So that's the deadline that the IRS had to assert the various penalties. And in that revenue agent report, again, the IRS asserted 4 different penalties under 6662. But because the IRS did not get written managerial approval of the penalties before issuing the revenue or issuing the revenue agent report to the taxpayer, the court actually strikes down the penalties on procedural grounds, which is significant. The taxpayer doesn't even have to argue necessarily reasonable cause. It's just pure procedure. The IRS did make an interesting argument in this. What they essentially said was, well, we're also asserting 6662I, which is an enhanced 40% penalty, and that was not necessarily raised in the revenue agent report, and they got approval for that penalty before issuing the revenue agent report. And what the court essentially holds is that no, the penalty, actually, the genesis of that penalty arises under 6662A and B6. It's just that I increases the penalty. So because the IRS did not obtain written managerial approval of the penalty under 6662A and B6 prior to the revenue agent report, that penalty is also struck down. Next slide. So Coleman v. Commissioner also came out fairly recently, I think in the last week or so. It actually deals with with gambling winnings and losses. And for those that aren't familiar, generally gambling losses can only be claimed up to the amount of gambling winnings under a special provision in the code. In this case, the taxpayer, he actually admitted that he was a compulsive gambler, and the facts indeed did show that he did gamble quite a lot. For his 2014 tax year, he received forms W2G from the casinos reporting 350,241 of gambling winnings. The IRS asserted in a notice of deficiency that he should pay income tax on those winnings, and the taxpayer disagreed, arguing that he had gambling losses at least equal to, and in fact, he argued more than 350,241 that was reported on the forms W2G. So the court in this case, and it was an interesting, it basically came down to what evidence could the taxpayer provide to the court to show that he had gambling losses, at least to the extent of his gambling winnings. The court actually held for the taxpayer on the basis of various evidence that was introduced. One piece of evidence was the taxpayer produced his financial records that reflected that essentially his financial position was still poor throughout all of 2014. In other words, there was not an increasing balance in any of his financial accounts. And in fact, in his retirement accounts, he was actually draining those as well. The taxpayer also, which is common in these cases, used his own testimony to support his arguments. But one other interesting aspect of this case is that he actually hired an expert to come in and do a statistical analysis of certain financial statements and other information the expert was able to get a hold of that concluded with a 99% level of certainty that the taxpayer had sustained sufficient gambling losses to wipe out his gambling winnings. Another interesting procedural aspect of this case is that the IRS did not introduce another expert to rebut the taxpayer's expert. And it actually was fairly significant in that on several arguments that the IRS tried to make against the expert report, the tax court actually held they weren't necessarily going to even look at those arguments because the IRS had not produced their own expert. So something to keep in mind, especially in the presentation of evidence in tax court cases on how to prove up your case. Next slide. The last case I want to go over is Doyle v. Commissioner, TC Memo 2020-139. the tax court continues to hear whistleblower cases on its docket. This was a whistleblower case. In this, it was two taxpayers had jointly submitted a Form 211 application for award for original information. The IRS whistleblower office issued a final determination denying any entitlement to an award because, at least according to that letter, the IRS took no action based on the information that was provided. After the taxpayers filed a petition with the tax court, as the IRS commonly does in these because it's limited to the administrative record, it moved for summary judgment. The taxpayers opposed. Next slide. So in this case, the tax court essentially denied the IRS's motion for summary judgment, and the basis was after a review of the administrative record of this whistleblower submission, there were facts that tended to suggest that IRS criminal investigation may have proceeded with an action for purposes of 7623B1. And what the tax court was essentially saying was that, well, the final determination letter said that there was no action taken by the IRS, but it appears based on the administrative record that there might have in fact been some actions taken by the IRS, and the IRS can't just rely on that final determination letter to kick the taxpayers' case out of the tax court. So those are the three cases that were interesting for purposes of recent tax court developments. And I'm now going to kick it over to Edward, who's going to discuss the next topic.
Edward, real quick, this is Greg Mitchell. Before we get moving to you, I will admit to being a rookie host, but Jason had to drop off for a minute. So I'm going to try to launch one of these polls. As you probably know, if you've joined one of these before, these are not hard-hitting questions, but they do need to be answered just for attendance purposes. And so I'm going to try to do this. The poll number one hopefully is on your screen. It asks the very difficult question of whether or not you're ready for 2020 to be over yet. And we're going to give everyone a chance to chime in with that. And I think based on the fact that we were a little slow with the first one, I'm going to go ahead and launch the second one after this, and then we'll kind of be caught up and then turn it back over to Edward. So I'll give you a few more seconds on this this poll number one, and with that, I'm going to close poll number one. Looks like we have about 85% of you that are ready for 2020 to be over, and 16% of you that I don't know what you guys are doing, but I'm jealous. So let's see if I can move this to poll number two, and we'll try and launch that. Poll number two says, which of the following is a current IRS enforcement priority? Based on what you've heard so far today, see if you can get that answer. Again, you're not going to lose points for wrong answers, but please do answer so that we can account for everybody being here. We're up to about 90% of you having voted, so I'll give you just a few more seconds. And with that, I'm going to close poll number two. Look like about 90% of you said conservation easements. Another 8 or 9% said PPP loans, and a couple percent said EIDL loans. No wrong answers. Thanks for voting. I'm going to, I could have shared the results. Maybe now you can see what I was seeing. I told you I'm a novice host, so my apologies for that. But with that, I'm going to turn it over to Edward.
Thanks, Greg. So my name is Edward Quartz. I'm a tax attorney. I typically focus on state and local issues. And today I'm going to go through and talk about Texas property tax or ad valorem tax and the appeals process. Because Texas does not have state income tax, the Texas government set up a system where counties can charge tax on property owned in the county, and typically they will assess tax on both real property and what is called business personal property. And as you can see on your screen, real property as defined in the Texas tax code can be land, mines or quarries, mineral interests that are still in the ground, standing timber or improvements. Business personal property, or BPP. Next slide, please. BPP is tangible personal property that is owned by a business that is used by the business to produce income. And examples of BPP would be things like the furniture, computers, inventory, and equipment that a business owns. It doesn't include intangibles such as goodwill, accounts receivable, stocks, bonds, notes, things like that. One of the interesting things about BPP is that each BPP owner is required to file a rendition with the appraisal district by April 15th of each year. And the rendition basically is an opportunity for the BPP owner to list out all of the assets that it owns that qualify as BPP and go ahead and give a market value for them, or what the value of those assets are on the company's books. The interesting thing about the rendition is that you are required to file one, and if you do not, then there will be a 10% penalty assessed against the property owner or the BPP owner if they don't do so. But of course the caveat there is there could be times or instances where it's beneficial to not file, because if you've gotten notices from the appraisal district in the past and they value your assets at a much lower rate than what you actually think they are, it might be worth it for you to not file the rendition and just basically lump the 10% penalty. But obviously that's a case-by-case basis. The appraisal method that the appraisal districts use is all based on fair market value. And as you can see on your screen, that the Texas tax code has kind of a system set up, or has a definition for fair market value. For those of you who live in Texas, I don't need to tell you that, what the appraisal districts think is fair market value and what the fair market value of the property is could, be wildly different. But, of course, once that appraised value comes out, then property owners, next slide, please, have an opportunity to appeal that appraised value. And the first step and the most important step, and I'll get to, you'll see why it's so important later, is to file the notice of protest. And that notice of protest needs to be filed by May 15th or 30 days after you receive the notice from the appraisal district of what the appraised value is. Whichever of those two dates is later. Next slide. So after you file the notice of protest, then you will get what's called a formal hearing with the appraisal review board. And this is really an opportunity for the property owner to come in and argue and present evidence to the appraisal board as to what the real value of the property is. And this is both real property and BPP. Obviously in this formal hearing, the count or the appraisal district will send in an appraiser, and they will present their own evidence to show why they think it's valued differently. But once each side is presented, the appraisal board will make a final determination, and then they will send out their order, which will give their opinion on what the value of the property should be. At that stage, the property owner has a few choices to make. They can be happy with the decision and leave it at that, or if they want, they can appeal that decision. And they have 3 options to appeal. The first is to go to district court and argue about the appraised value, at the court level. And if a taxpayer or property owner wishes to do that, then they have 60 days from receiving the order from the appraisal board within which to file the petition with the district court. With the other 2 options, binding arbitration or state or a hearing with the State Office of Administrative Hearings, the property owner's got 30 days within which to file the notice with the appraisal district that this is what they want to do. All 3 of these options, has pluses and minuses. Going to district court obviously is going to be the most expensive option because, you're going to have to hire a lawyer. Litigation typically is never cheap. And with binding arbitration and a SOA hearing, these are things that the property owner can do themselves if they so desire, or they can be represented by an agent. It doesn't necessarily have to be an attorney. With one thing to note with the SOA hearing is that after the property owner gives notice to the appraisal district that they want an administrative hearing, they have to mail a check within 90 days of $1,500 to the chief judge, the chief administrative law judge down in Austin, Travis County. And then once the SOA judge receives the check or the clerk receives the checks, and then they will docket the case with SOA. Next slide, please. Of course, what happens if the property owner fails to file the notice of protest? Well, if the property owner does that and doesn't actually go through the appraisal review board process, then the Texas courts have uniformly held that a property owner has not exhausted their administrative remedies, and therefore they cannot seek judicial review of the appraised value. So it really cuts a property owner off from any kind of appeal of the appraised value. They can't go to district court. They can't go to SOA. They can't go for binding arbitration, excuse me. So, this is why it's so important for a taxpayer to go ahead and get the process started by filing the notice of protest and going through the administrative process of the appraisal review board, because without it, it cuts off your access to any opportunity to appeal. Next slide, please. And then the last slide here is delinquent tax suits. And you'll see in a second why this kind of ties in. So in my practice, I have found, I've had several clients who have come to me, and it typically deals with BPP, where they have basically been like, hey, I've just received, I was just served, and now I'm being sued by the county for back taxes owed on business personal property. I didn't even know such a thing existed. What can I do? Oh, and by the way, what they're saying I owe isn't, is far greater than the value of what I have at the business. What can I do? And unfortunately, there really is not a lot you can do for a property owner in such a situation. Because they did not file the notice of protest, and because they basically just ignored any of the notices from the appraisal district, they cannot argue at the delinquent tax suit, or at this with this delinquent tax suit, that the appraised value is too high. They can't do that, and the tax code says that. There are numerous cases out there that say that as well. The tax code lists really only 2 affirmative defenses that a property owner can raise at a delinquent tax suit. And one is that, I don't own the property that was assessed for this year, for a year in question. Or alternatively, yeah, I do own that property, but it wasn't located within the county of the appraisal district. And so, those are the only two options. And so, to close, I would like to, just to let you know that if you have clients out there that have property tax issue, it's so important that they file the notice of protest, go through the administrative process with the appraisal review board, because if they don't, then they're stuck with that appraised value for that year. And, the process will start over for the next tax year, but for that year, they cannot, appeal the appraised value. So thank you very much. Greg?
All right, so before I get started telling you a little bit about bankruptcy, we're going to launch our third poll, and it's a little bit of a trick question, but the question is, are you still watching? If you're still watching, then please chime in. If you're not, then chime in anyway, and we'll give you a little bit of time to register your attendance. And even the 2% of you that say that you're not still watching, and I'll give you about another 5 seconds. If you saw in the chat window, if you're having problems seeing the polls, if you'll send a message to Jason Freeman directly, his email address is in the chat box. And with that, I'm going to end the polling of poll number 3. 98% of you are still watching. The other 2% are just wise guys, I suppose. So with that, we're going to move on to a little discussion of bankruptcy. And today we're going to talk about discharge issues. Generally, we will discuss these topics. What is a discharge? If you get a discharge, what exactly is discharge? And then we're going to talk about some exceptions to discharge, and you'll see a few there in front of you. Taxes, child support, student loans, reaffirmed debts. Some of those you're probably familiar with. Fraud is a little more, little less common, but still out there. And then debts that are not listed in the bankruptcy. So we'll talk about some of those. As most of you are probably aware, the primary goal of most Chapter 7 consumer bankruptcy cases is, in fact, to get a discharge. And so we'll start with a couple of simple questions. First of all, what is a discharge? And secondly, what exactly is discharge? You would think, or at least hope, that there would be simple answers to these questions, but as with most things legal, the devil is in the details, and the classic "it depends" is fortunately the true answer. But to the extent that there is a simple question to our first, simple answer to our first question about what is a discharge, it is that a discharge is the elimination of a debtor's legal obligation to pay a debt. Now, ironically, the bankruptcy code never really provides a definition of a discharge. Instead, it provides the effect of a discharge. So in section 524 of the bankruptcy code, which is title 11 of the US code, we see that a discharge does 3 primary things. Number 1, it voids any judgment whenever obtained to the extent that such judgment is related to the personal liability of the debtor. Number 2, it operates as an injunction against the commencement or continuation of any action in an attempt to collect that debt as a personal liability of the debtor. And number 3, it operates as an injunction against the commencement or continuation of any action against property of the debtor. So then, now that we have a general idea of what a discharge is, or at least the effect of a discharge, we get to perhaps the more important practical question, and that is, what exactly is discharged? Are all debts discharged? Well, clearly not. So the general rule is the debtor gets a discharge of all debts for which he or she is eligible to get a discharge on. Now, unfortunately, that may not be the most helpful description. The unfortunate thing about a bankruptcy discharge is that if you've ever seen one, it's a one-page sheet of paper that says the debtor has obtained a discharge. So for your benefit, this is the entire substance of what you will see in a bankruptcy discharge order. Now, the only thing missing is I've removed the names of the debtors, but that's the only other information that appears on the order. There's nothing on a discharge order that says what is actually discharged. Now, a discharge order does go on kind of below the order part, and it provides some general information to creditors about what may be discharged and what may not be discharged. But then in the same order, at the very bottom, it tells anyone that receives this that this information is only a general summary, and some exceptions exist because the law is complicated. You should consult an attorney. So kind of the bankruptcy court's version of the disclaim everything, and we're not providing legal advice. So in order to find out, we have to dig a little deeper and kind of take it on a case-by-case basis. So we started with the very general rule that a debtor gets a discharge of all debts they're eligible to get a discharge for. We can then proceed with some more, what I described as more specific general rules. And first, with respect to secured debts, while the debtor may get a discharge of a personal liability with respect to secured debts, if the debtor wants to keep the property, then they're going to have to make the payments. We'll talk in a minute about reaffirmed debts, but again, as a general rule, liens on property are not extinguished in bankruptcy, so a secured debt continues to be a secured debt. So for example, if you have a mortgage on your home, or if you have a loan on your vehicle, filing bankruptcy doesn't do away with the mortgage or the vehicle loan. If you want to keep the property, either the vehicle or the house, you're going to have to continue to make payments or you will eventually lose that property. Now, if you file bankruptcy and get a discharge, you may very well no longer have personal liability, which means that mortgage company or vehicle lender may not be able to sue you individually, but they can still come and get the property. So another general rule is that a debtor can be discharged of just about any unsecured debt. The most common unsecured debts that you'll see are credit cards, medical debt, things like that. Gosh, what other common unsecured debts would also include, for example, let's say you had a vehicle repossessed and the lender went and sold your vehicle, and as it turns out, they sold it for less than you owed, and there's this deficiency judgment. Well, that's an unsecured debt because that you no longer have the vehicle for them to come get. So again, general rule is that most unsecured debts are going to be dischargeable. But as we'll see, there are a variety of exceptions to discharge, which can be very important to whether or not it even makes sense to file for bankruptcy in the first place. So we don't have to look any further than the discharge statute itself to start to see some exemptions. So the statute in section 524A1 talks about judgments against the debtor, but only to the extent of personal liability to the debtor. So by reading between the lines, you can see a couple of exceptions kind of built in. For one, eliminating personal liability does not automatically eliminate liability of property of the debtor to the extent the creditor has a lien, kind of what we just talked about. Even though a debtor's homestead may be an exempt asset and a debtor may get a discharge of personal liability, it doesn't mean that the mortgage company can't foreclose on the property. Similarly, eliminating personal liability of the debtor does not automatically eliminate liability of a co-debtor. So for example, if a spouse doesn't file bankruptcy, but the spouse was legally obligated on some debt obligation of the filing spouse, then a discharge of one spouse doesn't affect the liability of the non-debtor spouse. This is a scenario that comes up not infrequently in the divorce context. A divorce decree may assign a particular liability to one spouse, but what happens if that spouse goes and files for bankruptcy? Well, the creditor, the entity to whom the debt is owed, is not bound by the divorce decree's assignment of the debt to one spouse or the other. So if the other spouse was also liable on the debt, then the creditor can go after the other spouse, even though the divorce decree says that it belongs to the filing spouse. Now, that other spouse might have a claim against the spouse that filed bankruptcy, and we'll see that one of the enumerated exceptions to discharge is a debt assumed in conjunction with an agreement incident to divorce. But nevertheless, the point is that a discharge of one person does not affect the liability of a co-debtor. A similar situation arises commonly when a parent co-signs for a vehicle loan for their child, and then the child defaults or files bankruptcy. That parent's obligation still exists. So let's talk about other exceptions. There are other statutory exceptions to discharge. Most of them are found in section 523 of the bankruptcy code, and I've just provided a list of a handful that we'll talk about. Number one on the list is income taxes. And of course, in the case of income taxes, there is an exception to the exception. For anyone that heard our last webinar, I discussed the three primary rules related to the discharge of taxes, those being number one, that the taxes must be more than 3 years old. Number two, it must be more than 2 years since the tax returns were filed. And number three, it must be at least 240 days since the taxes were assessed. If you meet all those three requirements, then income tax liability can be discharged. Property taxes are also non-dischargeable if they arose within 1 year before the date of filing. Trust fund taxes are also non-dischargeable if the debtor was a responsible person or a governing person that was required to collect or withhold them. That includes federal employment taxes. It also includes state and local sales taxes. 523 A1 Cap A, working in conjunction with the priority statute, gives us that. And unfortunately, unlike the income taxes, where there are these exceptions that if you satisfy those three requirements, you can still get a discharge, those do not exist with trust fund taxes. So if you're a responsible person with respect to trust fund taxes, bankruptcy is going to be of no help to you. Child support, that's one that a lot of people are familiar with, and you realize that you're not likely to get a discharge of child support. Student loans is listed as non-dischargeable in 523A8. Now there is an exception in the statute, but the threshold is extremely high, and I have seen maybe one or two cases ever, and it involved very extreme circumstances where someone may have been involved in a terrible accident. They're disabled, they can't work at all. They're not ever going to be able to make money again. And in those situations, you might be able to get a discharge of student loans. But a hardship discharge for student loans is very rare and very difficult to obtain. I won't get on my soapbox, but I think that's one of the code provisions that needs to be modified somehow. I'm not saying that that students should be able to walk out of college and into bankruptcy court and get rid of their debts, but I think we have a big problem on our hands that's going to come to some sort of bubble in the next few years with our student debt load that we have. Moving on, reaffirmed debts. 524C talks about agreements to reaffirm that must be made before the granting of a discharge. The most common reaffirmed debt is a vehicle. Most people, despite the fact that they filed for bankruptcy, even though they have a loan on the car, they still need their car in order to be able to get to a job, to take their kids to school, whatever it might be. And so the most common by far reaffirmed debt is a vehicle. There's quite a few requirements in the code that are designed to protect debtors from unscrupulous creditors that would try and get them to enter into a reaffirmation agreement. There's all sorts of disclosures that have to be made. The agreement has to be entered into prior to the granting of a discharge, and the debtor has 60 days to rescind that agreement. So even if the debtor signs, within that 60-day period, they can rescind their agreement and change their mind about reaffirmed debts. And those provisions are there to, like I said, protect the debtors. We don't have time to go into the details of some of the most, hotly litigated provisions, and those relate to allegations of fraud in obtaining the debt. But just as a very general example, if a creditor can show that a debtor provided false financial statements when the debtor took out a loan, then that could be the basis for a non-dischargeability finding. I will point out that for many of the non-dischargeability provisions, the creditor must affirmatively do something, which usually means filing what is known as an adversary proceeding in a bankruptcy case, which is essentially what I like to call a case within a case. It's a lawsuit that is filed in and actually tried in a bankruptcy court and is related to an underlying bankruptcy case. But it gets its own case number and it's tried just like any other lawsuit. It's just that it's tried to a bankruptcy judge. And I can tell you that adversary proceedings move much faster than typical lawsuits filed in state court. So that's, again, the point is that if you're a creditor and you think that you have a debt that is non-dischargeable, don't just assume that it's going to be non-dischargeable as a matter of law. You may need to file an adversary proceeding to have the bankruptcy court declare that judgment, declare that debt to be non-dischargeable. Now, there's a couple of them that are kind of automatic. The child support, like we talked about, the student loans, the taxes, those are obvious. The fraud allegations are not. And even if you have a judgment in a state court for fraud against somebody, it doesn't necessarily satisfy the requirements for non-dischargeability. So you may still have to try that in a bankruptcy court. And finally, and we're about to run out of time, 523A7 talks about debts not listed. With some exceptions, if a creditor is not listed in a debtor's bankruptcy schedules, then that debt may not get discharged. Now, if called on to do so, a debtor would have to show that either there was nothing for the creditor to get in the bankruptcy case, or that despite not being listed, that the creditor had actual notice of the bankruptcy filing. And with that, I'm going to launch our final poll and ask once again, are you still watching? If you are still watching, then say yes. If you want credit, say yes, give me credit. And of course, we're kidding, you'll get credit either way. We'll just let that run. But in the meantime, we are going to wrap up, and we appreciate you being with us today. And we look forward to seeing you at one of our next webinars. And I'll give you a few more seconds to finish that final poll. And we appreciate your attendance today. And you can feel free to log off whenever you are ready.